is Janna Wessels. I am Associate Professor at the Amsterdam Centre for Migration and Refugee Law at Vrije Universiteit Amsterdam. And I study the interaction between migration control and human rights law, and specifically the legal processes that define and determine this interaction. Most recently, I looked at how governments litigate before the European Court of Human Rights in Strasbourg on migration cases. And I found with my team that they engage in what we call reverse strategic litigation. And that reverse strategic litigation consists of three elements: doctrinal entrepreneurship, procedural ploys, and discursive framing that usually are engaged together. The concept of doctrinal entrepreneurship as one of the three elements that we identified for reverse strategic litigation is the deployment of legal arguments to shape the interpretation and application of human rights law. So actively seeking doctrinal innovation, pushing exceptions, and trying to get those accepted as doctrine. And that indeed works both inclusively and exclusively, because human rights as norms are openly formulated and allow for interpretations in both restrictive and inclusive manners. One example for an inclusive element of doctrinal entrepreneurship can be found in the famous case of Hirsi Yama from 2012 against Italy, where civil society pushed for an interpretation of jurisdiction for interception, so that jurisdiction applies even on the high seas. For an example for an exclusive variant can be found in the case of NDNNT versus Spain, where governments, intervening governments as third parties, proposed an exception to the otherwise absolute prohibition of collective expulsion. So doctrinal entrepreneurship is not limited to the courtroom. European governments navigate various interlinked arenas. That's indeed the European Court of Human Rights, but also UN human rights bodies, treaty bodies on the one hand, and charter-based bodies on the other as well. And the human rightization of migration discourse means that legal arguments are pervasive across all of them. So they all form part of the legal discourse on migrants' rights. There has also been an unprecedented rise in individual communications before treaty bodies. And treaty bodies have sometimes proven to endorse more protective interpretations. So where my next kind of research project will now be to analyze whether and how governments carry their strategies from the courtroom also across fora, and whether there is cross-fertilization, forum shopping, and those kinds of things. Yeah, I think the concept teaches us that actors engage strategically in litigation and beyond. So they co-shape the meaning of human rights law, and it's worth watching what arguments they advance, because even if they say fail, are not adopted by the court or treaty body or whichever body at a given moment, they often tend to come back. At least that's what we've seen in the litigation context. But it's worth also looking indeed beyond the courtroom and also at other fora to sort of take a multi-arena perspective on rights shaping. Human rights law is a contested field, and it's worth looking beyond the surface to understand how rights are shaped.